With Section 21 gone, in most circumstances, Section 8 will be the only route you can use to recover possession of a property. And that means you have to give a reason and rely on legal grounds. You also have to satisfy the court that you have a legitimate claim for possession. If you can't meet the requirements of the ground or the grounds that you're relying upon, you won't be granted possession. Now, these grounds aren't new. They've always existed in the assured tenancy regime, but there are now more of them, and some of those that landlords have relied on for years have been subtly or not so subtly changed by the Renters' Rights Act. There are lots of changes, but a few of them worth highlighting. If you or a family member want to move into a property, you would use ground 1. If you want to sell a property with vacant possession, that's now ground 1A. Both of these grounds require 4 months' notice, and importantly, you can't ask your tenant to leave within the first 12 months of that tenancy. Equally important, there are strict restrictions on reletting a property after using these grounds, so be very, very cautious if your circumstances change. When it comes to rent arrears, we still have the mandatory ground 8, but the bar has risen. A tenant can now owe 3 months' rent, not 2, before you can take action. And the notice period has doubled from 2 to 4 weeks. The arrears still have to be there on the day of the hearing, but any arrears resulting from universal credit delays won't be taken into account by the court. You'll also need the new prescribed Form 3A and solid records to back up your claim. In short, the takeaway: more evidence, longer notice periods, more planning. You really need to build a proper paper trail and do that early. If you're unsure, talk to us about which ground fits the bill and how best to proceed.